of it from a photographer in the room. It was in Pam Bondi's binder. It matched up with the searches that I actually did put into the computers. And this idea that the DOJ is spying on members of Congress using our search history as part of her burn book, that was the binder full of Oppo research on every single one of us as members of Congress, is absolutely unacceptable. It's a violation of the separation of powers. And I told Mike that, and I'm not going to reveal what he said, but I am going to say that we are demanding an end to that.
A member of the United States Congress went to the Department of Justice to read the unredacted Epstein files. The Attorney General of the United States showed up to the next congressional hearing with that member's search history printed out and tucked inside her binder. Reuters photographers captured the document. Agence France Presse photographers captured the document. The label on that printed page was clear and specific. Jayapal Pramila search history. Not a rumor. Not an allegation. A document photographed by two of the world's most established wire services and entered into the public record. And the congresswoman who was the subject of that surveillance said something in that hearing room that cuts to the center of everything this documentary is about. She said, "It is totally inappropriate and against the separation of powers for the Department of Justice to surveil us as we search the Epstein files." Let that settle for a moment. The branch of government responsible for investigating and releasing information about Jeffrey Epstein was caught tracking the searches of the branch of government responsible for overseeing that investigation. The Watcher device opens right here. Jeffrey Epstein surveilled his victims. The FBI investigated Epstein. Congress oversees the FBI. The DOJ surveilled Congress. The question this documentary is going to answer is not just what was in those files. To understand what happened in that hearing room, to know that Congress need to understand how the oversight process for the Epstein files actually works. After years of pressure from both political parties, the Department of Justice made a portion of the unredacted Epstein files available for congressional review. Not for public release. For members of Congress to read in a designated DOJ facility, under controlled conditions. Representative Pramila Jayapal of Washington State was among the lawmakers who went to the DOJ to exercise that oversight function. She searched the files. She reviewed documents. She used the access that the oversight process was designed to provide. That is not unusual. That is exactly what congressional oversight is supposed to look like. What was unusual was what the Attorney General brought to the next hearing. A printed document listing Jayapal's specific search history from her review of the Epstein files was in Bondi's binder when she testified before the House Judiciary Committee. Photos taken in that hearing room captured the document clearly enough that its title was readable. Jayapal found out about it the way everyone else did. From the photographs. She described the moment on the public record as the DOJ showing up with a burn book, a reference to keeping a documented record of someone's activities to use against them at a strategic moment. Her statement to Congress and to the public was direct. She said this was against the separation of powers. She said she had spoken to Speaker of the House Mike Johnson about it the previous night. She said she intended to pursue it and stop the spying on members. Speaker Johnson was briefed. That means both the Democratic Congresswoman who was surveilled and the Republican Speaker of the House were in communication about the same institutional concern. That is a bipartisan alarm. And it has received almost no serious coverage.
We asked Merrick Garland this.
I'm reclaiming my time, and when I reclaim my time, it is
Mr. Chairman, the gentlelady has reclaimed her
I'm not going
time.
to get in the gutter for her theatrics.
The time belongs to the gentlelady. The gentlelady has 17 seconds.
Thank you. You're not going to answer this question, so let me just
Chairman,
say
I'll
this.
direct it to
what
you.
a massive cover-up.
No, I'm answering a question.
Chairman, will you restore her time? The witness is
I'm not
interrupted.
going to get in the gutter with this woman.
Stop the
She's
time.
doing
So
theatrics.
friends, when it comes to legal
The gentlelady from Washington
court
controls the time. The gentlelady has
against
17 seconds.
Donald Trump
You can
and his
proceed with your final
corrupt
17 seconds.
What a
executive
massive
Attorney General Bondi's response to the accusation was that she was being dragged into the gutter for theatrics. But Jayapal's argument was not theatrical. It was constitutional. And the distinction between those two things is exactly what this documentary is built to explain. The separation of powers is not an abstract principle. It is the structural design of the American government. It means the legislative branch, the executive branch, and the judicial branch have defined spheres of authority. When one branch monitors the activities of another branch within that branch's constitutional function, it creates a structural problem that goes beyond any single political dispute. Congressional oversight of the executive branch is a constitutional function. Members of Congress reviewing Department of Justice files as part of that oversight function are exercising a power the Constitution specifically assigns to them. When the executive branch, in this case the Department of Justice, tracks and documents those oversight activities and then produces that documentation in a public hearing, it creates what constitutional scholars call a chilling effect. The chilling effect is specific. It means that members of Congress who know their searches are being monitored may search differently, may look at different documents, may avoid certain files because they do not want those searches to appear in the next hearing as a political weapon. If that happens, if congressional oversight is constrained by the fear of executive surveillance, then the oversight function itself is compromised. Jayapal said she had bipartisan agreement on that concern. The reference to Speaker Johnson's involvement confirms that this was not a partisan talking point. It was an institutional one. And it is the institutional dimension that connects directly to the Epstein case. Because the files that Jayapal was searching when her history was captured are the same files that multiple congressional committees have been pressing FBI Director Kash Patel and the Justice Department to release for over a year. Which means the surveillance of congressional Epstein file searches is not separate from the Epstein file story. It is part of it. Now let us talk about what Jayapal actually found when she reviewed the Epstein files. Because the surveillance story and the file content story are connected. And the content is what makes the surveillance significant. During the February hearing, Jayapal raised two specific pieces of information from the unredacted files that the DOJ had chosen to protect. The first was names. She stated that the DOJ had redacted the names of individuals described in the files as the men who abused the young girls. Not Epstein. Not Maxwell. The men who were the recipients of the trafficking operation. Their names were removed from what Congress was permitted to see even in the unredacted review session. The second was a specific documented request. Jayapal identified in the files a request for what she described as a torture video, connected to a named individual, Sultan Ahmed bin Sulaim. His email address was visible in the document. The video he requested was documented. But his identity, according to Jayapal's account, was protected in the DOJ's handling of the material. These are significant claims. They come from a sitting member of Congress who had direct access to the files and stated her findings on the official congressional record. They have not been independently verified through court documents or separate reporting available in the public domain. What is verified is this: Jayapal made these statements in a formal congressional hearing. She had just had her search history tracked by the department whose handling of those files she was describing. And the Attorney General's response was to call her line of questioning theatrical. Now here is where the Jayapal Bondi story connects directly to the FBI Director. FBI Director Kash Patel has been the central figure in every congressional Epstein hearing since his confirmation in February 2025. He has cited court orders. He has referenced the 2008 Acosta original sin. He has said everything legally permitted has been released. But the Bondi surveillance moment introduces a new dimension to that argument. If the Department of Justice is tracking what specific files members of Congress search when they review Epstein documents, and then using that tracking data as a strategic tool in congressional testimony, then the transparency Patel has described is not simply limited by court orders. It is also shaped by a monitoring system that determines what Congress knows, when they know it, and who in the executive branch is watching them find out. That is not a legal restriction. It is an institutional posture. Jayapal made this argument explicitly. She said the surveillance was against the separation of powers. She said it created a situation where lawmakers could not exercise their oversight function freely. In the same period, Representative Jayapal had also appeared at a September 2025 press conference with 10 Epstein victims. Those victims stood on the steps of the Capitol and called on Congress to pass legislation mandating the full publication of all documents related to the Epstein case. They were not asking for political theater. They were asking for the institutional process to deliver what it has consistently promised and not yet fully produced. The Watcher device is now fully in view. Epstein trafficked victims. The FBI investigated his network. Congress oversees the FBI and the DOJ. The DOJ tracked Congress as it tried to understand what the FBI has. And the Epstein victims are still waiting for a full accounting from all of them. Who is watching the people who are watching the files? That question is no longer rhetorical. It has a documented answer. The Department of Justice is. And what happens next in this story will determine whether that answer is the beginning of a new accountability process or the end of an oversight function that the Constitution was designed to protect. Stay with us. Because in Part 2 we are going to examine exactly what the 300 gigabytes of Epstein files that Congress was given access to actually contain, what the legal arguments for continued redaction actually cover, and the 3 specific developments in the coming weeks that will determine whether what Jayapal found in those files ever becomes part of the public record.
The subpoena to appear before the grand jury and testify truthfully about what he or she knows.
No, that's not the question. I asked you how many times did the president's name appear?
I don't know. For certain evidence.
It's your testimony. You do not know that.
When it comes to prosecutors issuing grand
could you
jury
tell us how many
subpoenas, we
agents
have
were diverted
almost
for this task
free
and what they were
reign,
working on?
right? Our discretion
When you say
is
diverted,
extraordinarily
make it seem as if
broad.
agents were pulled off.
The only thing we can't do
what they do
is use
all the
grand
time.
jury
Agents at the
subpoenas
FBI
for
masterfully
an
do double duty
improper
and triple duty.
purpose,
And because of the public's
like
interest in this
2 weeks before that September hearing, something happened outside this building that most coverage treated as a brief news item and quickly moved past. On September 3, 2025, 10 women who had survived Jeffrey Epstein's trafficking operations stood on the steps of the United States Capitol. They were not there to give interviews. They were not there for political theater. They were there to deliver a formal demand. They called on Congress to pass legislation mandating the full publication of all documents related to the Epstein investigation. Not a selective release. Not a court-ordered portion. All of them. These were not anonymous accusers. These were women who had participated in federal legal proceedings, whose accounts formed part of the evidentiary foundation that produced the conviction of Ghislaine Maxwell in December 2021. They had already given their most painful testimony in the most formal legal setting available to them. And 2 years after that conviction, they were standing on the Capitol steps asking Congress why the people around Epstein had still not been publicly identified. Jayapal was directly connected to that moment. She had appeared at that press conference. She had stood with those women. And when she sat across from Kash Patel 2 weeks later in the hearing room, she asked him directly whether he would bring those same women in to testify before Congress. Patel's response referenced meetings he said had taken place with victims. He did not commit to bringing them before the committee. That non-commitment is now part of the permanent hearing record. And 5 months later, when Jayapal went to the Department of Justice to read the unredacted files those victims had been asking about, her search history was in the Attorney General's binder. Now let us talk about the 300 gigabytes. That figure refers to the total volume of Epstein-related material that the Department of Justice made available for congressional review in their secure facility. To put 300 gigabytes in perspective, a standard feature-length film in high definition is approximately 4 to 8 gigabytes. A comprehensive federal investigation file covering decades of activity, thousands of documents, communications, photographs, financial records, travel logs, and video material would realistically reach that scale. 300 gigabytes is an enormous volume of material. And the portion of it that has been publicly released, the approximately 33,000 pages that FBI Director Patel has cited repeatedly in congressional hearings, represents a fraction of what lawmakers have been permitted to review in that secure facility. Here is the structural problem that creates. Members of Congress like Jayapal who go to the DOJ to review those files are not reviewing them for their personal knowledge. They are reviewing them to conduct oversight. To determine whether the executive branch is handling the material appropriately. to identify what additional disclosure the public record requires. That is the function. That is what the separation of powers assigns to the legislative branch. And when a member of Congress exercises that function, when she searches through 300 gigabytes of material looking for evidence of redactions that she believes shield powerful names, the question of who is watching that search is not a secondary concern. It is the primary concern. Because if the executive branch knows which files Congress is searching, and by extension knows which names Congress is trying to find, then the executive branch has an informational advantage over the oversight process that is specifically designed to check the executive branch's decisions. That advantage does not require anyone to actively obstruct anything. Simply possessing it changes the dynamic of every subsequent hearing, every subsequent document request, and every subsequent confrontation between an FBI director and a congressional committee.
To protect their identities. Let me show you what actually happened.
Let's start.
First,
with some great
in violation
reporting
of the law,
from
your department
Politico,
has shown a
and then
pattern
we'll
of
talk about a
redacting the
few
names
main
of
takeaways
powerful
from this
predators.
legal
Here
development
behind
that
me is one example
crushing
of an email
to
from
Donald
Epstein
Trump's
to a
dirty
man whose
Department of
name
Justice
was redacted.
leadership.
The email reads,
And this headline
quote,
starts with a quote
"Where are
from
you?
a federal
Are
judge
you okay?
who was appointed to the
I
bench by
loved
President
the
George
torture
W. Bush.
video."
Quote, blatantly
Only after
unlawful,
members of Congress
close
demanded
quote.
that we see
Judge
the unredacted
blocks
files
DOJ
did the
subpoenas
world
aimed
learn the name
at Tim
of this
Walz.
individual, Sultan
Judge Patrick
Ahmed bin
Schiltz said the
Sulayem,
grand jury
the
subpoenas
chairman
were,
and CEO
no
of a
doubt,
company that
aimed
had
at
financial
punishing
ties
Walz
to
for
President Trump's
refusing to
business
aid
and
immigration
personal ties to
crackdown.
Trump's advisors.
Crackdown. In a
Claiming
blistering
that
ruling.
The two specific findings Jayapal presented from her file review require careful, precise handling. Because they are significant claims made by a sitting member of Congress based on her direct access to unredacted material, and they have not been independently confirmed through court documents or separate reporting available in the public record. What is documented is this: Jayapal stated these findings in a formal congressional hearing under the same conditions of accountability that apply to all congressional testimony. Her account is on the official record. The first finding was about redactions of names. She stated that the DOJ had protected the identities of the men who were the recipients of Epstein's trafficking operation, the clients, as documented in the investigation files. Their names were removed from what Congress could access even in the secure review session. If that characterization is accurate, it means the current oversight process does not fully reveal the scope of who was involved. It means the information that the September press conference victims were specifically asking for, the names of the people around Epstein, remains protected not just from the public but from the legislative branch conducting oversight of the executive branch managing those files. The second finding was the Sultan Ahmed bin Sulayem detail. Jayapal described a documented request for what she called a torture video, with that individual's email address visible in the file and his identity protected in the DOJ's handling. Sultan Ahmed bin Sulayem is the chairman of DP World, a major Dubai-based port operator. Jayapal made this identification on the official congressional record. This claim has not been confirmed by independent court filings or reporting outside of Jayapal's testimony. It is presented here exactly as she presented it, as her account of what she read in a file she was authorized to access. The Attorney General called it theatrics. She said Jayapal was dragging her into the gutter. She did not say the files do not contain what Jayapal described. Here is what the documented record shows. 10 Epstein victims stood on the Capitol steps in September 2025 and demanded full disclosure. Their demand has not been met. Kash Patel testified before Congress that everything legally permitted has been released. He cited court orders. He cited the Acosta original sin. He cited 33,000 pages. Representative Jayapal went to the Department of Justice to read what 300 gigabytes of unredacted Epstein material actually contains. She found redacted names. She found a documented request for a torture video with a protected identity. She stated both findings on the official congressional record. At the next hearing, the Attorney General arrived with Jayapal's search history in her binder. Jayapal called it spying. She said it was against the separation of powers. She said Speaker Johnson had been briefed. She said she intended to stop it. Bondi called it theatrics. She said she was being dragged into the gutter. Here is the Watcher device in its final form. Epstein's victims were not protected when they needed protection. The FBI investigated what happened to them. Congress is overseeing how the FBI and DOJ are handling the files that document what happened. The DOJ is monitoring what Congress searches when they access those files. And the names of the men those files implicate remain protected from both public release and full congressional access. The people being watched, at every level of this story, are the people trying to find out what happened to the victims. The people whose identities are protected, at every level of this story, are the people the victims say were there. That is the documented pattern. It does not require conspiracy theory framing to be significant. The record produces its own weight. 3 developments to watch as this story continues. First, whether Jayapal's separation of powers argument produces a formal congressional investigation into the DOJ's surveillance of lawmakers' file searches. Speaker Johnson's involvement gives this bipartisan standing that a purely Democratic complaint would not have. Second, whether the Sultan bin Sulaim detail and the redacted names finding produces any formal document requests or subpoenas from the committee. Jayapal stated these findings on the record. That creates a documented basis for follow-up oversight action. Third, whether the Epstein victims' legislative demand, the bill mandating full publication of all Epstein documents, gains the bipartisan support needed to move forward. Marjorie Taylor Greene and Jamie Raskin have both publicly pushed for fuller disclosure. That bipartisan combination is rare and potentially significant. All 3 of these are active. All 3 are moving. And all 3 connect directly back to the same question the victims asked on the Capitol steps in September. Why are the names still protected? 2 questions for the AVA Reports community. The first. The Department of Justice tracked a member of Congress's search history when she reviewed Epstein files under the congressional oversight process, and then produced that search history in a hearing. Do you believe that action is consistent with the separation of powers? Or does it represent executive branch interference in the legislative branch's oversight function? The second. Attorney General Bondi did not dispute the content of what Jayapal said she found in the files. She called the questioning theatrics. If the files contain what Jayapal described, redacted names of clients and a documented request for a torture video, does the word theatrics adequately describe why those findings were raised in a congressional hearing? Drop both answers below. We read every comment. Subscribe to AVA Reports and hit the notification bell. The next documentary in this series covers what 3 former FBI directors said about situations exactly like this one, and why what they said then tells you everything you need to know about what is happening now. Thank you for watching.